Ladies and gentlemen, we don't regret the mergers and acquisition within the company because we believe that number one, which is the harm is mitigatable. It means it doesn't always happen, and even when happen, can be mitigated. So that's why it is not absolute. And number two, this is justify corporate strategy to be done. Before I'm going deliver my arguments, I will bring my rebuttals first. Moving on to my rebuttals, on the point of the harm provided by the affirmative side of the house, they basically concern about the access of privacy and also the breach of the privacy that done by this company. No, we said no, it won't happen because number one, that there is already law protecting the privacy, which we believe this is sufficient. Like for example, like UU ITE ensures that there is a cyber police to supervise, and there is law that allow shoe mechanism when violation happen. This ensures that those who feel that their privacy is being breached have access to go to court to ask for protection. So that's why it is sufficient to protecting the privacy. The law itself have a bigger rights to protect the privacy than the company itself. And number two, even if so, we believe that with acquisition, actually they are updating their term and condition and the privacy protection towards the corporation, which we believe is already accommodate the changes of the privacy, and they are also have the interest to protecting privacy because they are very aware the customers are very important. Most importantly, because they are also already a lot of cases where company upon releasing privacy, they can subject it to the court. It is already creating effect. For example, on what happened to Mark Zuckerberg, and it already called for privacy policy changes in Facebook. So they probably will not and does not willing their customers to live and hide the app that they're create, right? So that's why they will not actually taking a risk to losing their customers. Else we think the customers probably will be easier because of the merger or the acquisitions. Like for example, in the term of Gojek and Tokopedia merger named Goto, this merger actually helped the customers a lot with their service. Like when they have not making a merger or in the position of acquisition before, the delivery service like Tiki, Si Cepat, JNE, and etc. We still using that, right? And it actually using more money from the customers. But in the situation with Goto right now, when they have an acquisition, the delivery service being easier with Gojek company services because of the merger situation, and it actually help a lot, help more the customers and making it more easier. And number three, even if yes, there is a breach of privacy due to for example, targeted advertisement and whatnot, this is actually a discussion of other debate, which is the law of privacy. It doesn't happen because this merger, but the main cost of this happens is because the digitalizations of company and the failure of the government in creating a better law of privacy of protection. So that's why it more likely will not be create any collateral damage or harm. So moving on to my arguments that also going to be direct engaged with the second case of the affirmative side of the house. I will bring one point of arguments in this speech. Moving on to my arguments, how this is a valid and justify and right corporate strategy. We believe that as a corporation, you are in with your own strategy in creating addition. What type of strategy that we have? Number one, the size of company. Company have an inherent right to determine the number of employees that they want. Government cannot control the size of company. And number two, the type of company. Company can choose whether they want to be a retail, manufacturing, or any type of company as long as they can fulfill the criteria. And number three, the extension level of company. Company can buy new land for their office wherever and whenever they want as long as they fulfill the legal criteria. This should be applied in regard of the merger. As long as the merger done legally and transparent, we believe the company have the right to do so. Is enjoyed with the permit and also license even by the government, as well as the company does not harm or does not violate law that is provided by the company. What does this translate into? It translates into response towards the affirmative side of the house, where they believe that the level of violation will going to be worsened. We say no, these companies are still under the umbrella of labor protection, or else they will be going to be closed or considered as illegitimate by the government, and government can force the company to end their cooperation. So they are still under of the umbrella the umbrella of the law. If the labor violation still happen, we believe that this is not the failure of the company, but this is the failure of government in making the law. Returning then onto the principle and strategy, we believe that only the company are aware of their competition, so it is okay for them to creating a strategy to deal with the competition that they are facing, in which that this is in different type of company. For example, some company, yes, they probably have the ability to creating more creative strategies, more creating campaign and product interaction that might them appear better visibility in terms of competition. Number two, but there are also a company that have a power on the capital, and with this capital power not only related to the inherent right of the company, but most importantly this is related towards the survivability of the company. Survivability, we mean the merger and acquisition itself is one of the way for the company to be spread their wings more. Like when there is a company that not that famous or not that glorious but have the chance to get that, they will be able to be more spread and absorb the knowledge on the other company that merged them, like the knowledge about how they are be able to be that successful. It is like a mutualism, some symbiosis, like the other get more extension and the one who get acquired have the change more to be more successful with the help of this bigger company. But because we believe that by nature they are already in the competition, it means that they have a different mission and vision, but at the end they choose to buy, and actually means that they have no other option to do so. What does it mean? It means that the failure of them to merge will going to reflect into the survivability of the company. That is number one. Second of all, the failure on holding the merger will going to impact onto the trajectory of the business development. For the example, on Gojek right now probably is due to they basically do not have any other room of development. This will going to impact the worker even worse in comparison to in their rule, because with the merger it creates better development and better support from investors. Besides that, if we acquisited the other company, logically there will be any changing position of the direction, right? The employee will be changed and there will be any other or additional division, as both companies are now being work together, right? It will create more any job field specifically within the country itself. That's why it is not harmful, else it will be more beneficial for both companies to developing the amount of their profit if they are working together, which will help them more as the company to be developed and spread their wings onto the next level of company, like global company. And technology development actually is inevitable. Therefore, in the development of economy and company, the merger of technology companies will be inevitable, considering developing your own tech is expensive and takes a lot of resource. This is not only a natural development but also a necessary one for a company to adapt in the industrial revolution 5.0. So that's why we as opposition team so proud to oppose this motion. Thank you.